Will the members please rise for the invocation delivered by Pastor Tom Troth, Hillcrest Baptist Church, Frankfort, Kentucky, and remain standing for the Pledge of Allegiance.
Let's pray. Lord, as we begin day 33, we yearn for a better understanding of your Spirit, that we may have greater confidence in your guidance in our lives. Give us clear vision that we may know where to stand and what to stand for. Help us to know that unless we stand for something, we'll fall for anything. Remind us, O God, that you still have your hands on the controls of the universe. Though troubles and trials surround us, may we rest our minds on the fact that your sovereign hand guides us every step of the way. Help us to live this in every day of our lives according to the statement that appears above the dais at the front of this chamber, which states, "In God we trust." In Jesus' precious name we pray. Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you, Tom. Sure. Clerk will sound the chimes. Members will indicate your presence. Clerk will take the roll. Being 97 members indicating their presence, a quorum is declared and the House is ready to proceed. Next order of business, the excuse of absent members. Gentleman from Taylor.
Mr. Speaker, I move you, sir, that the absent members be excused in accordance with the House rules.
Without objection, so ordered. Gentleman from Taylor.
Mr. Speaker, I move to suspend the rules for the purpose of allowing members to co-sponsor bills and resolutions or to submit vote modifications and have filed the proper papers with the clerk to do so.
Without objection, so ordered. Next order of business, the approval of the journal. Gentleman from McCracken.
Mr. Speaker, I yield to the Clerk of the Senate.
Chair recognizes the Clerk of the Senate. Good afternoon, Madam Clerk.
Good afternoon, Mr. Speaker. The Senate has passed Senate Bills 52 and 124 and respectfully request concurrence of this honorable body.
Thank you, Madam Clerk.
Thank you, sir.
Thank you. Gentleman from McCracken.
Mr. Speaker, I move you, sir, that the journal from Monday, February 23, 2026 be approved.
Without objection, the journal from Monday, February 23rd, 2023 is approved. Next order of business, the second reading of bills. There being no need. Next order of business, report of committee. Please report.
The Appropriations and Revenue Committee has met and reports House Bill 1 should pass to rules with House Floor Amendments 1 and 2 and House Committee Substitute 1. An act implementing the Federal Education Opportunity Program in Kentucky. House Bill 2 should pass with House Committee Substitute 1, an act relating to Medicaid, making an appropriation therefore and declaring an emergency. The Local Government Committee has met and reports House Bill 246 should pass with House Committee Substitute 1, an act relating to animal control officers. House Bill 613 should pass, an act relating to revenues for the provision of emergency services. The Post-Secondary Education Committee has met and reports House Bill 94 should pass with House Committee Substitute 1, an act relating to post-secondary education. House Bill 307 should pass to rules with House Committee Substitutes 1 and 2 and House Floor Amendment 1, an act relating to proactive post-secondary admission. The Transportation Committee has met and reports House Bill 282 should pass with House Committee Substitute 1, an act relating to vehicle lights. House Bill 519 should pass, an act relating to operating a motor vehicle. House Bill 648 should pass, an act relating to motor vehicle dealers. And the Veterans, Military Affairs, and Public Protection Committee has met and reports House Bill 299 should pass with House Committee Substitute 1, an act relating to machine gun conversion devices.
Thank you, Mr. Clerk. All those bills and resolutions receiving favorable committee reports shall be considered as having their first reading and are ordered placed upon the calendar. House Bill 307 and House Bill 1, having had two previous readings, are ordered in the possession of the Rules Committee for further action. Next order of business, the orders of the day. Gentleman from McCracken.
Mr. Speaker, I move you, sir, that House Bill 1 be taken from the Committee on Rules and placed in the orders of the day for action today.
Without objection, so ordered. Gentleman from McCracken.
Mr. Speaker, I yield to the lady from Davis for an announcement to the majority.
Chair recognizes the lady from Davis 7.
Thank you, Mr. Speaker. On recess, the majority caucus will caucus in the annex caucus, or in the Capitol, in this building room. So upon recess.
Members take note. Gentleman from McCracken.
Yield to the lady from Fayette.
Chair recognizes the lady from Fayette 75.
Thank you, Mr. Speaker. Upon recess, the minority caucus will caucus here in the parking lot as well, sir.
Members take note. Gentleman from McCracken.
Speaker, I move you, sir, the House be in recess till the call of the chair.
Without objection, the House will stand in recess to the call of the chair.
House come to order. Gentleman from McCracken, we are in the orders of the day.
Thank you, Mr. Speaker. I move you, sir, that House Bill 568 would be taken from its place in the orders of the day, read for a third time by title and sponsor only, and placed upon its passage.
Motion is made and seconded that House Bill 568 be taken from its place in the orders of the day, read for the third time by title and sponsor only, and placed upon its passage. Clerk, please report.
House Bill 568, an act relating to public adjusters. Representative Meredith.
Gentleman from McCracken.
Mr. Speaker, I yield to the gentleman from Edmondson for explanation of the bill and motion thereon.
Chair recognizes the gentleman from Edmondson for explanation of the bill and a motion thereon.
Thank you, Mr. Speaker, ladies and gentlemen of the House. In 2023, the General Assembly passed House Bill 232, sponsored by the gentleman from Warren 17, to address the regulation of public adjusters here in the Commonwealth. Subsequently, that bill became a national model bill at the National Council of Insurance Legislators. In the 3 years since the passage of House Bill 232, we've continued to have issues with the profession here in Kentucky. When we presented this bill last week in the committee, both the Commissioner of the Department of Insurance and representatives of the Attorney General's office were with us because of ongoing complaints and investigations that have occurred in the industry. House Bill 568 prohibits new public adjuster licenses while allowing anyone currently licensed to renew their licenses. There are over 400 licensed public adjusters in Kentucky, and only 30 of those are residents of the Commonwealth. Largely in deference to those 30 in-state public adjusters, we chose to allow current licensees to renew their license into the future to not take any Kentuckian's livelihood away. The bill also has various conflict of interest provisions, including contracts must be enforced in a Kentucky court under Kentucky law, because we've seen out-of-state adjusters have clauses that require litigation to happen in their home state, even though they're operating in Kentucky under a Kentucky license. We further state that a contractor cannot solicit or obtain signatures on behalf of a public adjuster so that the consumer knows who they're doing business with. And we require a physical copy of the contract be provided to the consumer due to reports we have been given of electronic contracts being modified without the consumer's knowledge. The bill also creates a standard 5% fee cap for public adjusters. That 5% is not 5% on top of the claim. That 5% that they charge comes out of the actual insurance settlement claim. So that's on top of the deductible. It's another on top of fee. So this is a consumer protection measure as well. The original House Bill 232 allowed a cap of 15% for non-catastrophic claims and 10% for catastrophic claims. That has created a perverse incentive for public adjusters to backdate claims to dates prior to a catastrophe, which are suspicious at best. The standard fee cap for all claims will remove that perverse incentive. The bill will also prohibit a public adjuster from negotiating a claim. They will continue to have the ability to advise and assist the consumer, but will be prohibited from negotiation. This came as a result of finding a July 1995 opinion of the Kentucky Bar Association that makes it clear that representing a member of the public and accepting compensation in negotiating for and affecting the settlement of a claim for loss or damage is the practice of law in Kentucky. When such services are performed by one who is not admitted to the bar, there is a clear violation of Supreme Court Rule 3.020. That, ladies and gentlemen, is what House Bill 568 does. If you all have any questions, I would be happy to answer them. If not, I would move passage of the bill.
Question before the body is passage of House Bill 568. Is there any discussion? Seeing none, clerk will sound the chimes. Those in favor vote aye. Those opposed, nay. Roll call is open for your vote. Chair recognizes the lady from Davis 7 for explanation of vote not to exceed 2 minutes.
I would like to explain my yes vote today. I want to thank the gentleman from Edmondson, but also most importantly for all the people in my area that were exploited, absolutely exploited during the hailstorm this past year. So thank you, gentlemen from Edmondson, and look forward to this helping our future, any type of disaster that our people are not taken advantage of. Thank you.
Have all members voted? Clerk will take the roll. Being 95 members voting aye, 1 member voting nay, House Bill 568 is passed. Gentleman from Edmondson.
Move the clincher.
Without objection, so ordered. Gentleman from McCracken.
Mr. Speaker, I move you, sir, that House Bill 1 be taken from its place in the orders of the day, read for a third time by title and sponsor only, and placed upon its passage.
Motion is made and seconded that House Bill 1 be taken from its place in the orders of the day, read for the third time by title and sponsor only, and placed upon its passage. Clerk, please report.
House Bill 1, an act implementing the Federal Education Opportunity Program in Kentucky. Representative Moser.
Gentleman from McCracken.
Mr. Speaker, I yield to the lady from Kenton, 64, for explanation of the bill and motion thereon.
Chair recognizes the lady from Kenton, 64, for explanation of the bill and motion thereon.
Thank you, Mr. Speaker. Will you please have the clerk report House Committee Substitute 1?
Clerk, please report.
House Committee Substitute 1 to House Bill 1.
Lady from Kenton.
Mr. Speaker, all this does is allows Kentucky to opt into this federal education freedom tax program and ensures that no general funds, no Kentucky taxpayer dollars are used to administer the program. I move adoption.
Motion is for the adoption of House Committee Substitute 1. Is there any discussion of the committee substitute? Lady from Jefferson. Seeing none, those in favor signify by voting aye. Aye. Those opposed, nay. House Committee Substitute 1 is adopted. Lady from Kenton.
Thank you, Mr. Speaker. House Bill 1 would allow Kentucky primary and secondary students, K through 12, to take advantage of scholarships available as a result of the Federal Education Freedom Tax Credit Program. This federal program was established by Congress under H.R. 1 this past summer in 2025. The program will be implemented and administered without the use of any Kentucky taxpayer dollars. It authorizes the Secretary of State to opt into the Federal Education Freedom Tax Credit Program on Kentucky's behalf and administer the program. This measure would provide a significant tool for public schools to harness a federal tax credit to assist families and children to access school resources. It affirms our commitment to expanding educational opportunities and improving student outcomes. For years, too many Kentucky students have not met expectations, and more than half are not reading, writing, or doing math at grade level. So beginning in the 2027 tax year, this new initiative establishes a tax credit scholarship program designed to give families greater access to K through 12 options that best fit their child's needs. Federal law already allows Kentuckians to take advantage of this dollar-for-dollar federal tax credit of $1,700 by contributing to other states. But unless Kentucky opts in, we need to opt into this federal program, or Kentuckians will not benefit. House Bill 1 and the Education Freedom Tax Credit will not cost Kentucky taxpayers a dime, but would allow Kentucky students to take advantage of scholarships granted by scholarship granting organizations, or SGOs. Under this model, public schools could establish their own independent scholarship granting organizations to collect donations, just as they do with other nonprofits like PTO or athletic boosters to administer SGO funds. So what this bill does, again, it authorizes the Secretary of State to opt into the Federal Education Freedom Tax Credit Program on Kentucky's behalf and administer the program. The bill allows private donors to make a donation to a nonprofit scholarship granting organization in Kentucky and receive a dollar-for-dollar tax credit, federal tax credit, of up to $1,700. These donations go to an SGO in Kentucky and simply bring in more money into Kentucky schools, and benefit Kentucky families and children. You're going to pay the money anyway, so it's your choice. Either pay the federal government or bring the money home to Kentucky students. Even Democrat Governor Jared Polis of Colorado said, "This supports donors to give more money to our schools. It would be crazy not to." It baffles me that our governor, Governor Beshear, who constantly talks about putting more money into education, has already attacked this opportunity for Kentucky schools to opt into this program. This puts more money in Kentucky schools. The scholarship granting organizations are nonprofit organizations that receive private contributions and transform those dollars into K through 12 scholarship opportunities for students in public, private, and homeschool settings. They award scholarships that help students access educational opportunities that might otherwise be out of their reach. Their mission is straightforward: expand access and empower families by helping cover the cost of educational pathways that best fit each child's needs. School districts can organize an SGO, and SGOs collect donations and solicit applications for scholarships. Scholarship granting organizations would then distribute the scholarships to families for a number of educational services, including, but really not limited to, tuition, tutoring, technology, transportation, special needs programs, instructional materials, and school supplies for public schools. The scholarships would be available for families who earn up to 300% of their area's median income. H.R. 1, the federal bill, required that SGOs be certified by every state in which they operate. And so we are not eligible unless we opt into this. The law sets clear guidelines for how the funds are used. At least 90% of the contributions must be used to and awarded as scholarships to students. This really prioritizes supporting middle and low-income households. House Bill 1 is constitutional. While our Kentucky courts have misguidedly determined that state dollars cannot be used on anything other than common schools, this is a federal tax credit program. 27 states have opted in so far, many being blue states. At this point, Mr. Speaker, I'd like to yield to the gentleman from Boone 66 for some comments on the bill.
Chair recognizes the gentleman from Boone 66.
Thank you, Mr. Speaker. House Bill 1 really is a simple question. Do you want this federal tax cut to benefit Kentucky students, or do you want this federal tax cut to benefit non-Kentucky students? Personally, I choose Kentucky. House Bill 1 is simply opting us in to a federal tax cut that has already been implemented at the federal level. No state dollars are touched, and every Kentuckian can already donate to a scholarship granting organization. And I'll be one of those Kentucky taxpayers donating to a scholarship granting organization. Whether that donation benefits a student in Kentucky, or benefits a student in Ohio, or Indiana, or Colorado, depends on this vote. I want it to benefit a Kentucky student. I want it to benefit a Kentucky student who grew up in a household similar to my own, where I was raised in a low-income household. I was raised by a single mother with the help of my grandparents. My mother worked like crazy to make sure that me and my sister got the best opportunities that we could. And thank God she did, and thank God that I did just fine in the public education that I went to from 1st through 12th grade. That said, my educational needs are not the needs of every other student. There are students with special needs. There are students who don't have the same learning style as myself. House Bill 1 looks out for them and puts the Kentucky students first and ensures that we are capable of providing the best opportunities for every student, regardless of their income. This bill is simply about the average Kentuckian. This bill is about those who otherwise can't afford those opportunities. This is for the forgotten generation of students who have been denied that opportunity to excel and to experience the blessings of this nation through a sound education and career readiness. The revenue that could come into our schools is astonishing. Democrats for Education Reform issued a statement where they listed the potential revenue to schools in each state, and if so much as 1% of Kentuckians participate, that is more than $8 million for Kentucky schools that we will not see otherwise if we do not pass House Bill 1. If we are similar to our neighbor to the north, Indiana, that is at least $25 million going to our schools that would not be there otherwise, without costing a single state general fund. House Bill 1 in that way is simply common sense. And to reach across the aisle, Nebraska Democrat Senator Justin Wayne once said in relation to a similar issue, "My community can't wait another generation. If we care about kids, then get rid of the politics of it and let's give them a chance." House Bill 1 gives Kentucky kids a chance. For those reasons, I urge that we pass House Bill 1 and enact it into law. Thank you, Mr. Speaker, and I yield back to the lady from Kenton 64.
Lady from Kenton.
Thank you, Mr. Speaker. If there are no questions, I move adoption of House Bill 1 as amended by House Committee Substitute 1.
Question before the body is passage of House Bill 1 as amended by House Committee Substitute 1. Chair recognizes the lady from Jefferson 32 for discussion of the matter.
Yes, sir. May I speak on the bill?
Yes, ma'am.
In the few hours between last Thursday and today, I've taken a really deep dive into Section 704.411 of Public Law 11921, which is what House Bill 1 refers to in its language. And I came upon a document on regulations.gov where there was an option for public comment on the federal tax scholarship program. And overwhelmingly, the comment was not on how the regulations need to be written, but strong opposition to the program's core design. Concerns about money being transferred away from education, from public education and into private education. And I do share those concerns. But the more I read about the federal law, the more I thought about how, if we are very intentional, we can ensure that this money can transfer to our public education students. It's really powerful. And so Section 530 of our Internal Revenue Code covers the Coverdell Education Savings Account. And that is referred to in the federal law about what things you can cover with these scholarship tax credits. The only thing that a public school student could not obtain would be tuition. But public school students could receive scholarships for fees, academic tutoring, special needs services, books, supplies and other equipment, room and board, uniforms, transportation, extended day services, computer technology, and even internet access for the families at home. Could get a scholarship to help your family cover the costs of internet access to support your child's learning. Thoughts include school lunches and breakfasts. We still charge for these. You could get a scholarship for that. Transportation in Jefferson County to magnet schools. Required supplies. I mean, maybe you don't need a scholarship to buy all those tissues, but the money adds up. If you add it together, just 1,000 donors at $1,700 are $1.7 million. I am urging public school advocates to find someone to create a scholarship granting organization in order to pull those funds in to support our public school students. We overwhelmingly in this state believe in our public schools. And my goal in this floor speech is to encourage everyone who's interested in our public schools to ensure that there's a scholarship granting organization that supports the students to whom you would like to support. Thank you.
Thank you, Lady from Jefferson. Chair recognizes the gentleman from Campbell 67 for discussion of the matter.
Thank you, Mr. Speaker. May I ask the lady from Kenton a question?
She will yield.
Thank you. And just I'm trying to understand, if you could help me, why are we waiving immunity granted to the Commonwealth under the 11th Amendment in this bill?
Lady from Kenton.
Thank you, Mr. Speaker. I'll give my quick explanation, and then I may yield to my co-sponsor. But from what I understand, this would simply allow the federal court, should there be any sort of contest, any sort of lawsuit in this, as it pertains to this bill only, that it would be heard in the federal court, not the state court, because this is a federal program. It's a federal tax credit.
Gentleman from Campbell.
So maybe, could I ask a follow-up or clarification of that question?
Yes.
So, I mean, what I'm trying to, so we have, in revised statutes, chapter 49060, we have generally preserved immunity, sovereign immunity for Kentucky. We have a board of claims that is generally there to administer, if somebody has damages against the state, it's usually administered through the board of claims. I mean, my understanding of this bill is, somebody's damages could be about $1,700 a year if they max out their tax credit, and that seems like something that could be perfectly handled under the Board of Claims. I guess that's what it seems like a very big step to waive our sovereign immunity for an administrative amount of money. Could you clarify again? Thank you, sir.
Gentleman from Boone 66, would you yield to that question?
Yes, Mr. Speaker. So to answer the question, there are multiple types of judicial immunity doctrines. You have sovereign immunity, which is established by state statute. You have qualified immunity, which is immunity from damages claims, as the gentleman from Campbell 67 was addressing. Then you have 11th Amendment immunity. 11th Amendment immunity is simply the notion that if it is a state claim, it is to be addressed in state courts. That is what the immunity that is being addressed in this language. 11th Amendment immunity is waived for the purposes of this statute to specifically state our acknowledgement that this is the implementation of a federal program. We believe that in matters of interpreting federal law, the federal courts are more well equipped to address the merits and the substance of the law, as it is Congress that enacted House Resolution 1, not the Kentucky General Assembly. We are simply opting into an enactment of that. For those reasons, we believe that any claims arising out of this, and by the way, this doesn't open the Commonwealth of Kentucky to a claim for individual damages against any state actors. This is asked in terms of what does this law mean. We are consenting to the jurisdiction of federal courts to determine its meaning, to determine the lawfulness of how this bill is currently drafted. And we believe, based on the fact that it was a federal legislature that adopted it, a federal court should be interpreting it.
Gentleman from Campbell.
Thank you. May I ask the gentleman from Boone one more point of clarification?
He will yield.
Thank you. So I'm just trying, let's say if this bill passes, it becomes law, and the Secretary of State screws something up in the future, somebody in Kentucky doesn't get their $1,700 tax credit from the federal government. Does this mean, I'm just trying to understand what this means practically. So does this mean that taxpayer could sue the Secretary of State in federal court, or does this mean, I guess, what? Can you help clarify this for me?
Gentleman from Boone.
Mr. Speaker, the waiver of 11th Amendment immunity would not open the Secretary of State's office to any form of liability. They are not the ones who implement the tax credit program. That would be the Department of the Treasury as administered through the Internal Revenue Service. If an individual makes the contribution and is not given the tax credit, that would be a claim under the federal law. That would not be against the Secretary of State. So it would only mean that for the interpretation of our state opt-in, that the federal court has the jurisdiction to address that substance. There is no liability created in any individual capacity actors under this statute.
Gentleman from Campbell.
Thank you. That takes care of it.
Chair recognizes the gentleman from Henderson for discussion of the matter.
May I ask the sponsor a question?
She will yield.
So I just want to clarify that you said that if Kentucky does not opt into this, then Kentucky taxpayers could go to states like Indiana who have opted in and donate to an SGO in those states.
Lady from Kenton.
Yes, gentlemen, that is correct. Any individual can opt in or can contribute to an SGO in a state who has opted in, but that would not benefit Kentucky students.
Gentleman from Henderson.
May I speak on the bill?
Yes, sir.
I live in Henderson County and am a public educator in Henderson County. And we live very close to Evansville, Indiana, who we compete with quite often on workforce development and other areas. And I can't bear the thought that Kentucky, Henderson taxpayer dollars might be able to cross the bridge and cross the river over to Indiana and benefit students there when it could be staying in our community and benefiting students and workforce development, whether that be at Henderson County High School for an after-school tutoring program or Holy Name School for tuition. And for that matter, I'm going to be a yes on this. Thank you.
Chair recognizes the lady from Jefferson 34 for discussion of the matter.
Thank you, Mr. Speaker. I'd like to make a motion. Mr. Speaker, I rise pursuant to Rule 11 to make a motion to lay House Bill 1 on the table, and I request a roll call vote.
Motion of the lady from Jefferson 34 is to lay the bill on the table. Requires majority of those, under Rule 11, requires majority of those members elected. So require a constitutional majority of 51. Roll call is open for your vote. Those wishing to lay the bill on the table, vote aye. Those opposed don't have to do anything. Motion receiving 19 votes in favor, motion fails. From Jefferson 34, floor is still yours.
Thank you, Mr. Speaker. The reason I have called for this to be tabled is because this bill was just filed last Thursday, the 19th. Its first reading was given on Friday, the 20th. And this was just heard today in Appropriations and Revenue. Today's the 23rd at 12 o'clock. It also was accompanied by a committee substitute, which the public still does not have access to. Our members that sit on A&R just received that committee substitute last night. So without giving our members here in the General Assembly or the public the opportunity to read and analyze this bill, it erodes public trust and the process. There is no need to rush this bill. We could take a vote on this at a later date. So with that, while we are not able to table it, I would encourage the members to think about the way that you vote today and make sure that you're not eroding that public trust with the constituents that you represent. Thank you.
Chair recognizes the lady from Jefferson 41 for discussion of the matter.
Thank you, Mr. Speaker. I'd like to speak on the bill.
Yes, ma'am.
Thank you, Mr. Speaker. I've been here a long time, as have you, and we've been through many budget sessions in the years, and every time that we need money, we cut education. this bill, even though it is federal statute, it comes from federal money, it's still tax dollars that are going to be reimbursed. And I'm afraid it's going to open the door to vouchers and charters, which in 2024, Kentuckians overwhelmingly supported our public schools on a constitutional amendment vote. The process, as the lady from Jefferson 34 said, has been to rush this through with the public having pretty much no input, legislators having pretty much no input, but filed on the 19th and today is the 23rd, so 4 days for a bill of this magnitude. And I understand that it's about giving $1,700, which is basically a bill for the wealthy people, because poor people aren't going to be able to afford $1,700 to go to a scholarship fund. And then to get a tax credit back, which we're already giving rich people tons of tax credits and tons of our money. But we have underfunded our schools yet again, according to this budget. And in the past, we've underfunded them. Even whatever party was in control, we've always underfunded our education. And in full disclosure, my daughter and son-in-law are public school teachers, and they're always having to buy supplies, paper, glue, pencils, pens, computers, pay for field trips for their kids. The teachers even take care of their kids' personal needs, feminine hygiene products, coats in winter, socks, underwear, gloves, scarves, hats. We've got to quit underfunding our public schools, which are so important to our thousands and thousands of kids, and teachers, and classified staff, and retirees across this country. The fear that this is the road to vouchers and charters is really a slap in the face to our teachers, our classified staff, who often work just for a paycheck for their health insurance. But I'm really disappointed that we are passing this bill in 4 days when most of us haven't even seen a committee sub. I think we should take a step back. I know we're not going to, but I would love to take a step back and see what the full cost of this could be, how much money it's going to put in the pockets of the very wealthy. And sometimes programs like this are totally rife with people using money for trips, for whatever, and stealing money from where it should go.
Lady from Jefferson 41, I've allowed quite a bit of latitude.
Okay, I'll just talk about the bill. But what we need to talk about is funding our education, and we've talked about this over the years, is funding education properly and putting 15 students in a room, having 15 students, paying our teachers more. And unfortunately, I don't think this is the right way to do it. Thank you, Mr. Speaker.
Chair recognizes the lady from Jefferson 38 for discussion of the matter.
Thank you, Mr. Speaker. I rise to act on a floor amendment. Would you allow?
You're certainly allowed to make a motion, lady.
Thank you. I'd like to, today I filed floor amendment 6 to House Bill 1. And I would like to make a motion for us to suspend the rules due to the fact that the committee sub was filed today for that amendment to be heard. So I'd like to move to suspend the rules to hear House Floor Amendment 6 to House Bill 1, and I'd ask for a roll call vote.
Roll call.
Lady from Jefferson 38's motion is for suspension of the rules for the purpose of allowing floor amendment 6 to be acted upon. Motion to suspend the rules is not debatable, requires a constitutional majority of 51. Roll call machine is open for your vote. Those in favor of suspending the rules, vote aye. Clerk will take the roll. Being 19 members voted aye, falls short of the required 51 votes for suspension of the rules. Lady from Jefferson 38, the floor is still yours.
Thank you, Mr. Speaker. May I speak on the bill?
Yes, ma'am.
Thank you. Mr. Speaker, you often hear me talk about the legislative process in this body. Today is no different, and I filed an amendment today to the committee sub, even though it would be out of order and we'd have to suspend the rules in order to hear it, because I think that input and feedback from the public and from our members is vital to the legislative process. One thing that the bill is lacking is the proper oversight to this federal scholarship tax credit to make sure that we know who's benefiting from this program, who is putting in the dollars, who is getting the return on investment. We need to know those things as a legislature. That is our job. So my floor amendment would have actually added more data to be collected by the LRC and the Interim Joint Committee for Appropriations and Revenue and Education, so that way we could have learned the following data points. The number of children and number of households receiving scholarships, the demographic data of the households for the students that are receiving the scholarship, and the household income of those receiving the scholarship. These are important pieces that we need to know so that we can make sure that this is benefiting the people that we intended to benefit in Kentucky. This is just one reason why there's no need to fast track this bill today. This is a bill that we all knew was coming eventually. So why are we not giving the public time to look at the committee sub, to give us impact, to see the safeguards that can be put in place, and actually to really mindfully take time to consider those changes? Mr. Speaker, I think I belabored the point, and so I'll sit down. But I think we need to be really mindful about these things, and so I'm going to be a no today on pure process alone. Thank you, Mr. Speaker.
Chair recognizes the lady from Fayette 93 for discussion of the matter.
Thank you, Mr. Speaker. May I ask the sponsor a question, please? She will yield. Thank you. Amendment 2 was rejected by voters across all 120 counties. The outcome was an overwhelming majority of Kentuckians said no public tax dollars should be spent on private schools.
Lady from Fayette 93, this is about a federal tax credit, not a Kentucky tax credit.
That's still public dollars, correct? Federal money still funded by the public?
Those were state tax dollars that were contemplated.
So my question is, can you explain to constituents and voters across the Commonwealth why this legislature should circumvent that decision through a federal tax mechanism?
Lady from Fayette 93, that House Bill, or Amendment 2, is not the subject of this debate. This is House Bill 1 from the 96th session. If you'd like to ask a question on this bill, then you're recognized to do so. Otherwise, you're out of order.
Thank you, Mr. Chair. Yield to another question.
If it's in order.
I believe it is. Private schools receiving indirect public benefit through this federal program are not bound by the same civil rights, disability access, or open enrollment requirements as public schools. How can we justify that double standard to parents of children with IEPs and 504s?
Lady McKinnon.
Thank you, Mr. Speaker. I would just like to clarify that because this is a federal tax credit, the Americans with Disability Act and Title IX protections remain in place. I believe that is the protection that you're concerned with, and those protections are.
Question? May I ask another question?
She will yield.
Thank you. And I'll get back to that. What academic performance reporting will be required of the schools whose students receive the scholarships?
Lady from Kenton.
Thank you, Mr. Speaker. The scholarship granting organizations set their own parameters as far as the scholarships that will be granted. And so it's really going to be up to the SGOs to determine those specific programs.
Lady from Fayette.
Okay, thank you. Let me ask another question.
She will yield.
Thank you. And I'm asking this for clarification. I'm not an attorney. Subsection 5 waives Kentucky's 11th Amendment sovereign immunity. Can somebody, or can you explain, you or the gentleman from Boone?
Lady from Fayette, the gentleman from Boone answered that question from the gentleman from Campbell.
I was simply going to ask, who are they concerned might sue the Commonwealth?
Gentleman from Boone, 66.
Mr. Speaker, Kentucky has a broad standing requirement to really minimize it. In many ways, anyone could. That being said, our governor, who claims to be the education governor, which sure, he may be the education governor of Ohio, he may be the education governor of Indiana, he may be an education governor of any of the other 27 states that have opted in, but he's not the education governor of Kentucky through his opposition to this bill and the threats of litigation against this bill. This bill makes it to where this can be handled by the appropriate authorities. In terms of our standing doctrines, it's extraordinarily low, and so we want to make sure that this is handled in a jurisdiction that is competent to handle federal law.
Lady from Fayette.
Thank you, Mr. Speaker, and thank you for the non-answer. May I ask one more question?
I don't believe he will yield to another question. Lady from Kenton, you're not required to yield.
I'm fine not yielding, thank you.
No, they will not. You'd recognize to speak on the bill.
Thank you, Mr. Speaker. The governor is given supreme executive power by Section 69 of the Constitution and charged by Section 81 to take care that laws are faithfully executed. It is broad-reaching, sobering responsibility. The Secretary of State, our Secretary of State has done an exceptional job over the last 7 years, and I'm thankful that he is the one in that office. But the Secretary of State is given one job in the Constitution, and that's recording the acts of the governor, and that's under Section 91. So the question I had planned to ask was, why is the decision to participate in this federal tax program better suited to the Secretary of State than it is to the governor? But that question will go unanswered. What I can say is, voters already spoke on this type of bill in 2024. It wasn't even a close call. This bill doesn't change the underlying policy reality. Federal tax credits for donations to private school scholarship organizations redirect money that would otherwise flow to the U.S. Treasury and ultimately to public schools through federal education funding. The General Assembly is trying to accomplish through a federal tax mechanism what the voters of this Commonwealth explicitly refused to authorize directly. This is an end run around the democratic will of the people. The federal tax credit under 26 U.S.C. Section 25F rewards wealthy individuals and corporations for donating to SGOs instead of paying federal taxes. Every dollar sheltered through this credit is a dollar not flowing back to Kentucky through federal education grants. Rural Kentucky counties, already operating on razor-thin school budgets, depend heavily on federal Title I funding, IDEA funding, and other federal education dollars. This program structurally disadvantages them for the benefit of private institutions concentrated in urban areas like mine, that most rural families cannot access. The federal tax credit is most valuable to high-income donors who have large federal tax liabilities to offset. Low and middle-income Kentuckians don't benefit from this mechanism at all. They don't have enough federal tax liability to make it worthwhile, so ultimately this is a subsidy for the wealthiest dressed up as educational opportunity. The families in rural Kentucky who voted down Amendment 2 don't have a private school within 50 miles. going to skip the rest of that part. The way I see this, the General Assembly is seizing authority that isn't clearly ours. Subsection 1A has the General Assembly designating itself as the state authority to make this election on behalf of the Commonwealth. Handing ourselves administrative duty, or then handing administrative duties to the Secretary of State. It's a legally awkward construction. The governor as chief executive is traditionally the authority for executing federal-state agreements. With the waiver of the sovereign immunity, I believe that's also a red flag for us. And one of my colleagues has brought up SGOs are private organizations. There's very little accountability and oversight for how money will be spent. Under this bill, the Secretary of State collects a fee and publishes a list, and that's the extent of the oversight. There are no requirements for academic performance reporting in this bill, no civil rights compliant mandates, no transparency requirements for how scholarship funds are spent, or which students are accepted or rejected. Private schools receiving indirect public benefit through this program can still discriminate in admissions based on religion, disability, or other factors. Kentucky's public schools simply can't do that, and that's a fundamental inequality. The core message here is simple. The people voted, and the legislature should listen. And finally, to the teachers and public school supporters who are watching, these guys are trying to find another way to defund public schools, this time with a backdoor voucher. It doesn't matter if the money comes from the federal government or from Mars. It doesn't matter if it's funneled through the Secretary of State or in tax returns. It doesn't matter if they offer the same option to public schools, and quite frankly, I have zero confidence that would even materialize. What matters is how the money is spent. If it's spent in any way for anything other than public schools, I argue it's unconstitutional. Thank you, Mr. Speaker.
Chair recognizes the gentleman from Boone 66.
Mr. Speaker, in the interest of transparency, I'm going to explain what the committee substitute does. All the committee substitute did was eliminate Section 2 of the Act, and the reason why that section was eliminated was because 26 U.S. Code 25F subsection E already covered what we aimed to accomplish with Section 2. That is all that the committee substitute did. Now, throughout this debate, we've heard the allegations of fraud, waste, and abuse on these issues. And to be clear, the federal government has a statute that criminalizes honest services fraud. If an SGO is formed and defrauds students and denies them educational opportunity, I hope they rot in federal prison. I hope they're indicted for that. But the reality is this. This tax credit already exists. Kentuckians can already donate. They are donating right now. This is why we cannot wait. This is why every single day that this bill is not law in the Commonwealth, students out of Kentucky are benefiting from Kentucky donors in 27 other states. Every day we hold up on this bill is a day a Kentucky student is denied education freedom and the ability to have the best education that they are entitled to. And on this notion that a tax cut is tax dollars, the Supreme Court of the United States has already rejected that. That's Espinoza versus Montana Department of Revenue. And on to Amendment 2. Amendment 2 is simply about state tax dollars. This is a federal tax cut. Article 6, Section 2 of the United States Constitution makes clear that when there is legitimate federal law and legitimate state law that are in conflict, the federal law prevails. Article 1, Section 8, Clause 1 of the United States Constitution gives Congress the power to set the federal tax policy. That conversation's already over. This bill was signed into law on July 4th, 2025. This is already the law. There's nothing that can be done in that area. To the points about advocating for public schools, making sure teachers aren't on the hook for every single expense that students otherwise cannot afford, I hope that House Bill 1 enables public schools to set up SGOs to cover for these students, to ensure that they are looked after so teachers aren't forced to bear that burden. But the reality is this. In terms of data collection, anything to add duties to the LRC, anything to add duties to any other executive branch agency, that would be general funds. That is what the other side of the aisle has argued against throughout this. as to why we put it into the Secretary of State. Mr. Speaker, Form 15714 from the IRS expressly authorizes, as the statute does, for other agencies in the state to administer the program. That is why we are doing this. But the reality of why are we not giving this authority to the governor? It's because, simply put, due to his magnificent case of Trump derangement syndrome or freedom derangement syndrome, whatever you want to call it, he won't do it. He's openly hostile to anyone but the super wealthy having the opportunity to send their kids to the school that best serves their interests. It's interesting coming from a guy who himself went to private schools as a result of his own platinum spoon that he was born in his mouth. But the reality is this: these kids deserve that chance. House Bill 1 gives everyone the same opportunity, levels the playing field, so I urge passage of House Bill 1. Thank you, Mr. Speaker.
Chair recognizes the gentleman from Jefferson 33 for discussion of the matter.
Thank you, Mr. Speaker. May I speak on the bill?
Yes.
Thank you, Mr. Speaker. I'm going to make just a couple points because there's a lot of yarn being spun in here today. I want to be very clear about just 3 points. There's 10 or 11 I can make, but number one, if you make $25,000 a year, your federal income tax is $2,802. I don't think, contrary to what my good friend, the lady from Jefferson 41 said, that this isn't eligible for folks to contribute and to donate for people going to school unless they're fat cats. I don't think somebody making $25,000 a year is a fat cat, and they can contribute, and I think they'll want to do so. The second point I want to make is, contrary to what the lady from Fayette 93 said, the governor is not the supreme executive. That is not the Kentucky system. The Kentucky system diversifies executive power into many offices. And I know she knows this because she even cited the right constitutional section, Section 91. But had she been more full in her explanation, she would have also included the sentence in the section that I know she knows because she cited it. It says the duties of all of these officers shall be such as prescribed by law. So to stand up on this floor and to say the governor is a supreme executive and all the Secretary of State does is just this little scrivener thing is, I'm not allowed to say pejorative, so I will say less than honest, Mr. Speaker, deliberately so. And I will say the third thing. And I hope every member on this floor, am going to donate. I just hope it goes to a Kentucky poor kid and not an Indiana poor kid. Thank you, Mr. Speaker.
Chair recognizes the gentleman from Spencer for discussion of the matter.
Speaker, I rise to speak on the legislation.
Yes, sir.
Mr. Speaker, over the weekend I saw a lot of social media posts about this legislation as it was introduced. I've heard some comments on the floor here today. First, I've been aware of this for a long time because I keep up with what's going on in Washington, D.C. So as soon as this passed out of D.C. in House Resolution 1, I took the opportunity to review the legislation to see the implications for Kentucky. The gentleman from Boone 66 filed a very similar bill, House Bill 88, early in the session. So this has been out there for a while. Now, there have been a lot of comments made, but I'd like to share some facts that I believe that are not in dispute. One fact is Congress passed House Resolution 1 that included this provision. Another fact is that there will be individuals all across the United States who will be making donations to these scholarship granting organizations, including here in Kentucky. Another fact, there will be scholarship granting organizations in states that take applications from individuals, from parents, and if they are approved based on the criteria in House Resolution 1, their children will have the opportunity to use those funds, possibly at a private school, but also possibly at a public school. That is not what's in dispute. The question we have before us today is whether or not Kentucky is going to opt into this program. And the federal legislation really does not have much, does not give the state many choices. The option is, do you opt in or do you opt out? And who do you designate as the agency in your state that's going to oversee the registration of these scholarship granting organizations and report that to the federal government? That's really all House Bill 1 is about, Do we opt in, and who do we designate? We have so many discussions. I hear so many other topics, Mr. Speaker. And I get so frustrated that when it comes to issues like this, they turn so partisan. My heart's about our children in this state and their future. And I want every child in Kentucky to have the best opportunity they can, whether they attend a public school, a private school, or whether their parents choose to homeschool. This is just an opportunity that is available to the citizens of the Commonwealth of Kentucky if we're willing to give them that here today. So I urge my members to vote yes on House Bill 1. Thank you, Mr. Speaker.
Chair recognizes the gentleman from Lincoln.
Thank you, Mr. Speaker. The opposition continues to make this discussion about private schools, but it is not. Every single public school in this state can benefit from this plan. The majority, I want to clear up something real quick too, go back just a hair there, Mr. Speaker, if you'll allow me. The majority has never cut education in the previous budgets that we've done, as was just insinuated a few minutes ago. Matter of fact, even in the tougher years, we continue to fund education at record levels. We continue to do that. Matter of fact, I don't know where the governor got his information here recently, but in one of his speeches, he even said that public education was fully funded, whatever that's supposed to mean. But a lot of people in this state are going to take advantage of this. There are folks right now that are taking advantage of certain things and sending money out of state to help students. They want to donate right here in this state. 27 other states are doing it right now. Their money is going to go to those other states. But I tell you what, if that money is going to happen, my local school system in Lincoln County or Garrett County, they can set up one of these granting organizations. They can do that themselves. They can get the donations into that granting organization. And if folks are going to give those funds, I want it to stay right there in my hometown. I want it to help my public school students. That's why this bill is so important. This is a chance to get more funding in public education, not what the talking points are that are written on those pieces of papers for the other side are talking about. And I'm going to tell you that a no vote on this bill today is exactly what the opposition is telling you. It is a vote against public education. Thank you, Mr. Speaker.
Chair recognizes the gentleman from Perry. Discussion on the matter.
Speak on the bill, Mr. Speaker.
Yes, sir.
I've sat here and debated on whether to talk with myself, whether to talk on this bill or not. But listening to the folks in opposition, I decided I need to talk. So I just Googled 10 poorest counties in the U.S. The number one example of the 10 poorest counties in the U.S. is one of my counties that I represent, Owsley County, Kentucky. I plan on helping Owsley County start one of these SGOs so that those that are in opposition to this bill, if they don't want the money to come to their counties, they can have them send it to Owsley County's SGO so that the poorest kids in my district can have a ride after school to an after school program, or have access to tutoring, or have access to the things that they deserve in the poorest county, one of the poorest counties in America. If it really is about the kids, as everybody always says, then everybody in this room should go home, get with your school district, have them start an SGO, and start trying to campaign to get money for your SGO so that your poorest kids can be looked at and looked after. My understanding is this is to help the poorest of the poor. There are no big private schools in Owsley County. There are no big private schools in Breathitt County. There's some Christian schools in the counties, but there are no big highfalutin private schools where rich kids are going to benefit. And if you doubt my word, you can come get in the truck with me Friday, and I'll drive you to Owsley County and let you see right where my people live and how this will benefit the people that I love, because to me, it truly is about the kids. Thank you, Mr. Speaker.
Thank you, gentleman from Perry. Question before the body is passage of House Bill 1. Clerk will sound the chimes. Those in favor vote aye. Those opposed, nay. Roll call is open for your vote. Chair recognizes the lady from Kenton 63 for explanation of vote not to exceed 2 minutes.
Yes, Mr. Speaker. Pursuant to Section 57 of the KY Constitution, I wish to be recorded as abstaining.
Madam Clerk, please let the record reflect the lady from Kenton 63's abstention. Chair recognizes the lady from Fayette 75 for explanation of vote not to exceed 2 minutes.
Thank you, Mr. Speaker. I would have loved the opportunity to be brought to a yes. I was a passing committee and would have absolutely loved to be able to get to a yes. But the debate on the floor today really left me wanting, and it wasn't the policy debate, the high overarching things about what this really represents. It was the ad hominem attacks. That means attacking a person. Sorry, like my public school education got ahead of me there. It was the attacks on our governor combined with the terrible procedure that put me in a stance where I'm voting no. I wish I could be a yes, but the untruths spoken about the governor today have yet to be corrected, and so I'd like to defend our public educated governor who went to Henry Clay High School in Lexington, where I'm from, went to UVA and Vanderbilt, all public schools. So I'm afraid, yes, classy public, sure, yeah, it's better than many of us went to, but you know what? They're public schools. And I think it really shows me a lot when the main thing you want to argue about is the person you hate and not the policy you love. So I'm a no, because today you didn't win on policy.
Chair recognizes the lady from Fayette 76 for explanation of vote not to exceed 2 minutes.
Thank you, Mr. Speaker. I'm in a little bit of a weird situation where there were parts of this bill that I was very tempted to vote for. You all know that I love my nonprofit communities. I reached out to some of our groups in Fayette County that I thought could become SGOs. And I will continue to work with them to try to make sure that we can maximize this opportunity for our public schools. I think the gentleman from Henderson 11 and the lady from Jefferson 32 made excellent points to that impact. However, what really finally persuaded me that this was not the vote, and let me back up there. I think the rhetoric from both sides of the aisle on this is not true to what the bill actually says. The fact that we are talking about H.R. 1, that is a bill that many of us have tracked. We don't know all of the details. Many of our constituents have not had a chance to review all of that. That's also why I thought that we should have tabled the conversation so that we could invite more experts to the table to have these conversations and work out the details. But ultimately, when the lady whose district number I am blanking on voted to abstain, that tells me that it is actually related to vouchers, and that gives me a lot of heartburn on it, and so I am voting no on that. Thank you.
Chair recognizes the gentleman from Boone 66 for explanation of vote not to exceed 1 minute.
Mr. Speaker, Kentucky students win with this vote. This was an opportunity to ensure that our children are what the members of this body are loyal to. And for that reason, I vote yes. And to be clear, none of this affects the United States Department of Education funding. It's already allocated. Children have won today. Thank you.
Chair recognizes the lady from Jefferson 41 for explanation of vote not to exceed 1 minute.
Thank you, Mr. Speaker. I'm voting no on this bill today because my fear is that kids and parents are going to think a scholarship is going to pay their way or pay their tuition. They're going to be in for a rude awakening when tuition at some of these private schools is $15,000 to $20,000 a year. So I'm voting no on this bill. Thank you, Mr. Speaker.
Chair recognizes the lady from Jefferson 32 for explanation of vote not to exceed 1 minute.
Yes, I'll do this quickly. I went from yes to no to yes to no to yes. It's a really, really hard vote for me. But I believe with my heart and soul that this will help public education students. And so I'm going to stick with the yes because I'm going to do everything that I can to ensure that we have scholarship granting organizations that help public education students and students with disabilities.
Chair recognizes the gentleman from Jefferson 46 for explanation of vote not to exceed 2 minutes.
Thank you, Mr. Speaker. Those that have been here a while know I have a history on this issue. It's a very tough bill for me for many reasons. Till we called it today, and then it became an easy vote. Although I really can't vote no on this because of the arrangements with federal monies, I can choose not to participate. We could have easily done this tomorrow. There were several amendments filed today. I've seen them all online, standing up there filing them. Many of them were not called because probably they knew they weren't going to get a chance to vote on them because they were out of order and there wasn't going to be passage. And so I will choose today not to participate on this bill. I'm sure it will move forward. It's just something that I decided I'm tired of participating in processes like this when we could easily ran this bill tomorrow. Thank you, Mr. Speaker.
Have all members voted? Clerk will take the roll. Being 79 members voting aye, 17 members voting nay, House Bill 1, as amended by House Committee Substitute 1, is passed. Lady from Kenton.
I move for clencher.
Without objection, so ordered. Gentleman from McCracken.
Mr. Speaker, I move you, sir, that House Bill 627 would be taken from its place and the orders of the day read for a third time by title and sponsor only and placed upon its passage.
Motion's made and seconded that House Bill 627 be taken from its place in the orders of the day, read for the third time by title and sponsor only and placed upon its passage. Clerk, please report.
House Bill 627, an act relating to insurance. Representative Bray.
Gentleman from McCracken.
Mr. Speaker, I yield to the gentleman from Rockcastle for explanation of the bill and motion thereon.
Chair recognizes the gentleman from Rockcastle for explanation of the bill and a motion thereon.
Thank you, Mr. Speaker. Would the clerk please report House Committee Substitute 1?
Clerk, please report.
House Committee Substitute 1 to House Bill 627.
Gentleman from Rockcastle.
So within the bill, we give the Attorney General the jurisdiction to prosecute any PIP crime. We received some language from the Department of Insurance, and we incorporated that within House Committee Substitute 1. And with that, I move adoption.
Motion is for the adoption of House Committee Substitute 1. Is there any discussion of the committee substitute? Seeing none, those in favor signify by voting aye. Those opposed, nay. House Committee Substitute 1 is adopted. Gentleman from Rockcastle.
Thank you, Mr. Speaker. House Bill 627 addresses issue with personal injury protection within our auto claims. The problem is currently the statutes say that every PIP medical bill is presumed to be reasonable, no matter how much the provider charges. And so what we have here is if we've implemented several changes to PIP, we've put it on a workers' comp fee schedule. We require that payments be submitted quickly, that claims be submitted quickly. We require annual insurance fraud report by the Department of Insurance, with the idea being we want to make sure that we've got adequate protections on the book so that if you're in an auto claim or if you're in an auto accident, you can stretch those dollars further. We passed this bill out of this body last year, and since then, there's been quite a bit of work that's gone in there. We've made several concessions in working with the Justice Association, the Chiropractors Association, and the PTs Association. They are all neutral on the bill. Mr. Speaker, I'd be happy to take any questions, but with that, I move passage of House Bill 627 as amended by House Committee Substitute 1.
Question before the body is passage of House Bill 627 as amended by House Committee Substitute 1. Is there any discussion? Seeing none, clerk will sound the chimes. Those in favor vote aye. Those opposed, nay. Roll call is open for your vote. Have all members voted? Does any member wish to change or explain their vote? Clerk will take the roll. In 85 members voting aye, 9 members voting nay, House Bill 627, as amended by House Committee Substitute 1, is passed. Gentleman from Rockcastle.
Move the clincher.
Without objection, it's ordered. Gentleman from Kraken.
Mr. Speaker, I move you, sir, that House Bill 422 be taken from its place in the orders of the day, read for a third time by title and sponsor only, and placed upon its passage.
Motion's made and seconded that House Bill 422 be taken from its place in the orders of the day, read for the third time by title and sponsor only, and placed upon its passage. Clerk, please report.
House Bill 422, an act relating to crimes and punishments. Representative Pfister.
Gentleman from Kraken.
Mr. Speaker, I yield to the gentleman from Woodford for explanation of the bill, a motion thereon.
Chair recognizes the gentleman from Woodford for explanation of the bill and a motion thereon.
Thank you, Mr. Speaker. I'd ask that the clerk report House Committee Substitute 1 to House Bill 422, please.
Clerk, please report.
House Committee Substitute 1 to House Bill 422.
Gentleman from Woodford.
Mr. Speaker, I move for adoption of the committee substitute.
Motion's for the adoption of House Committee Substitute 1. Is there any discussion on the committee substitute? Chair recognizes the gentleman from Fayette 45 for discussion of the committee substitute.
Thank you, Mr. Speaker. Wish to speak on the committee substitute briefly.
Sir.
I just want to thank the gentleman from Woodford for his collaboration in this process. For those who are going through it on their screen, you look at the top of page 9. And additionally, when someone's sentence had expired, but they thought that there was a need for more continued service after that, the only option in there was involuntary hospitalization. And I want to thank the Woodford and others working on this bill for allowing mandatory supervision as an option, as well as outpatient treatment as well. So I think this committee substitute makes this bill better. And again, I want to thank those for working on it, for being willing to work with us across the aisle to improve this. Thank you, sir.
Motion is for the adoption of House Committee Substitute 1. Those in favor signify by voting aye. Aye. Those opposed, nay. House Committee Substitute 1 is adopted. Gentleman from Woodford.
Mr. Speaker, in 2015, a 6-year-old little boy named Logan Tipton was stabbed to death while he slept in his bed by a total stranger who had broken into his home in Versailles. His father and siblings were stabbed during the incident, and the perpetrator was subdued by his father and held for police. At the trial, the perpetrator received 20 years for the assaults and was found not guilty by reason of insanity for the murder. Due to mandatory release statutes, the perpetrator was released over the objection of the parole board after serving just 10 years. While he promptly violated his probation and was returned to jail, he will be released back into society in just a few months without any supervision at all. House Bill 422, which has become known as Logan's Law, is a truly bipartisan collaboration to protect the citizens of the Commonwealth. This bill was built on the input of the Tipton family, and many of the members, including the gentleman from Boone 66, the gentleman from Jefferson 33, and the subcommittee, as we heard a moment ago, was from recommendations from the gentleman of Fayette 45. This bill also has over 62 co-sponsors at the last count. The purpose of House Bill 422 is to bring some sanity to our insanity statutes, get rid of mandatory early release, and disallow juries from splitting the insanity defense as it did in this case, to protect our citizens by getting those suffering from mental illness the needed help, and to enhance the notice requirements to the victims' families when criminals are being released. Mr. Speaker, if there are no questions, I move for passage of House Bill 422 as amended by House Committee Substitute 1.
Question before the body is passage of House Bill 422 as amended by House Committee Substitute 1. To recognize the gentleman from Clark for discussion of the matter.
Thank you, Mr. Speaker. May I speak on the bill?
Yes, sir.
Everything we put up on these screens are very important. These are things that we have to attend to. But there's none more important than what we're doing today here. Logan's Law is simple. It's violent criminals should serve their full sentence. No early release, no loopholes. Kentucky families deserve safety. I stand with victims, not violent offenders. Logan's Law makes sure dangerous criminals stay behind bars where they belong. In small towns across Kentucky, one violent crime like this can really shake the whole community. Logan's Law puts accountability first. When this story broke back during the summer, I was sickened by it, and I was going to take action during the interim. But when I heard that the gentleman from Woodford was taking the lead on this, I backed away and fully supported him. The soft no-crime approach has failed. Logan's Law restores common sense to the crime. And if you do the crime, you serve the time. Our deputies and police risk their lives every day, and Logan's Law backs them by keeping repeat violent offenders off the streets. We can uphold justice without compromising our values, and I'm committed to fighting for common sense sentencing that keeps dangerous people off the streets. This law means accountability over catch and release, justice over bureaucracy. Logan's Law will strengthen sentencing and restrict early release for violent criminals who service our communities or terrorize our communities, especially in rural and small town Kentucky. And I just want to close with this. The majority of us in here today are Christian, and I'm proud of that fact. But let us never forget the words of Jesus Christ when he says in Matthew 17, it's better to put a millstone around your neck and to be cast in the deepest sea than to hurt one of his little ones. Thank you, Mr. Speaker.
Chair recognizes the lady from Jefferson 38 for discussion of the matter.
Thank you, Mr. Speaker. Will the gentleman yield to a question?
He will yield.
Thank you. Gentlemen, it's my understanding that this bill requires a fiscal note of some sort, either a corrections impact statement or a local mandate. Have those documents been prepared for the bill or the committee substitute?
Gentleman from Woodford.
We have requested them and they have not been returned yet.
Lady from Jefferson 38.
May I speak on the bill?
Yes, ma'am.
Mr. Speaker, I'm happy to support this much-needed legislation. I think we cannot be doing enough to protect our children, and so I'm really excited to get to vote on this bill. However, I just want to, again, caution us on the process that we have the corrections impact and the local mandates for a reason. It's a budget session. We really need to make sure that we're giving our folks that work in our prisons all the tools that they need to make sure that they can appropriately administer this law because it's so important. So I just wanted to put that on the record, and thank you, Mr. Speaker.
Chair recognizes the lady from Jefferson 41 for discussion of the matter.
Thank you, Mr. Speaker. I just want to speak on the bill.
Yes, ma'am.
Thank you, Mr. Speaker. I was president in judiciary when Logan's dad came, and it was the saddest thing I'd ever heard, to see one of your children murdered in that way. But I don't know if this is the right way to go about it, to keep somebody in with no possibility of parole, because then they have no reason to behave themselves or to keep themselves from harming our underpaid, overworked corrections officers. Also, I believe this guy got out with no wraparound services. And obviously, he was terribly mentally ill. And as we know, we've underfunded mental services, not only in this state, but across the country. And I couldn't help but think if he had been identified early, probably in high school, he probably tortured animals or something, that we could have prevented a terrible tragedy like this. And I don't know what I'm going to do with this bill. It breaks my heart to think that that could happen to any of our families at any time. And it's very frightening, but I think we need to think also about what we're doing as far as keeping people in forever or 35 years without any services at all, and what it does to our corrections folks that work so hard. Thank you, Mr. Speaker.
Chair recognizes the gentleman from Boone 66 for discussion of the matter.
Mr. Speaker, I just want to address the body about the mechanics of what House Bill 422 does. This bill is doing justice for Logan Tipton and people like him to ensure that something like what happened to the Tipton family never happens again. And in the event that we lose one of Kentucky's children ever again, true justice is done. This bill's been months in the making based off of the failings of our justice system that resulted in the release of a monster who should have never seen the light of day after taking a child from his family. House Bill 422 does a few things in three main categories. The first one is mandatory reentry supervision reform. The first one, it makes clear that no mandatory reentry supervision will be available for those convicted of a Class B felony or convicted of a violent felony, but was unanimously denied by the parole board. This is in response to the MRS release of the monster that killed Logan Tipton, and the fact that this individual was unanimously denied parole every single time he went before the parole board. It requires annual reporting so we can get further information about the efficacy of our MRS program. Second, it adds consistent sentencing for violent felonies. For intentional murder, it becomes a jury decision. Not automatic, it is a jury decision for life without the possibility of parole. You intentionally kill one of our Kentuckians, that is the proper remedy. And further, it adds value to every victim and ensures consecutive sentencing for every victim of a violent crime. Further reforms our insanity defense to be clear that for you to be found insane, you must have had such a mental illness that you did not know what you were doing. We have the loosest insanity defense law in the country, and this fixes that. It helps protect the public, and it finally prohibits split verdicts. So that way, if you have a single indictment with multiple counts, either you're sane or you're insane. You're either going to jail or you're going to an asylum. This is a common sense reform to ensure that we do justice for Logan. It's endorsed by the Commonwealth's Attorneys Association, and I would support its passage. Thank you, Mr. Speaker.
Question before the body is passage of House Bill 422 as amended by House Committee Substitute 1. Clerk will sound the chimes. Those in favor vote aye. Those opposed, nay. Roll call is open for your vote. Does any member wish to change or explain their vote? Chair recognizes the gentleman from Jefferson 30 for explanation of vote not to exceed 2 minutes.
Thank you, Mr. Speaker. I'm glad that we're passing such a bipartisan and impactful bill today. And of all the provisions, I think the most important one was just explained by the gentleman from Boone, that if you aren't well enough to be held accountable for the consequences of your actions, you are not well enough to be released to the general public. I was proud to vote yea. Thank you, Mr. Speaker.
Have all members voted? Clerk will take the roll. There being 93 members voting aye, 1 member voting nay, House Bill 422, as amended by House Committee Substitute 1, is passed. Gentleman from Woodford.
Mr. Speaker, I move for clincher.
Without objection, clincher is applied. Gentleman from McCracken.
Mr. Speaker, I need to yield to the gentleman from Todd for an announcement.
Chair recognizes the gentleman from Todd.
Thank you, Mr. Speaker. Make an announcement to the body. There will be a special called meeting of a House Appropriations and Revenue tomorrow at adjournment in room 131. The agenda and committee subs are already out by email. Thank you, Mr. Speaker.
Gentleman from Todd.
I'm sorry, but in addition to that announcement, we've run into some particular difficulty in getting one of those committee subs out. And I just want to alert you, Mr. Speaker, and others that we have also pursued a separate proceeding. Not since my time here have I seen it done, but as I understand, subpoenas have been issued to the executive branch for certain information has been withheld. We hope to receive that soon so we can begin to go through it. Thank you, Mr. Speaker.
Thank you, gentlemen. Gentleman from McCracken.
Mr. Speaker, that concludes the orders of the day.
Next order of business, motions, petitions, communications, and announcements. Gentleman from McCracken.
Mr. Speaker, I move you, sir, that House Bill 500, 501, 503, 504 be taken from the Committee on Appropriations and Revenue, given their first readings, and then returned to the Committee on Appropriations and Revenue.
Without objection, so ordered. Clerk, please report.
House Bill 500, Representative Petrie, an act relating to appropriations measures, providing funding and establishing conditions for the operations, maintenance, support, and functioning of the government of the Commonwealth of Kentucky and its various officers, cabinets, departments, boards, commissions, institutions, subdivisions, agencies, and other state-supported activities. House Bill 501, Representative Petrie, an act relating to appropriations, providing financing and conditions for the operations, maintenance, support, and functioning of the Transportation Cabinet of the Commonwealth of Kentucky. House Bill 503 with House Floor Amendment 1, Representative Petrie, an act making appropriations for the operations, maintenance, and support of the legislative branch of the Commonwealth of Kentucky. And House Bill 504, Representative Petrie, an act making appropriations for the operations, maintenance, support, and functioning of the judicial branch of the government of the Commonwealth of Kentucky and its various officers, boards, commissions, subdivisions, and other state-supported activities.
Gentleman from McCracken.
Mr. Speaker, I may need you to come back to me shortly, but at this point I would like to yield to the lady from Davis for some announcements, including a birthday.
Chair recognizes the lady from Davis.
Thank you, Mr. Speaker. And yes, with the 60-day session, it's chances we're going to have a lot of birthdays. So we do want to wish the lady from Boone 60 a very special happy birthday today. And then I have a couple more announcements, but let's go ahead and wish her a happy birthday. In behalf of all the members, we want to thank the Kentucky psychologists for joining us today. So happy to have them in the building. And also want to make an announcement. The Electric Co-op and IOU is having a reception this evening. The Foundry from 6 to 9.
Members take note. Chair recognizes the gentleman from Lincoln. For what purpose, sir?
Call the legislative citation, Mr. Speaker.
Yes, sir.
Could I ask the clerk to report legislative citation 35 by title only?
Clerk, please report.
Citation 35, Representative Meade, Representative Baker, Representative Branscombe, Representative Bray, and Representative Upchurch. Citation of appreciation. The home of the House of Representatives of the Commonwealth of Kentucky hereby recognizes and honors Anthony Tony Campbell.
Gentleman from Lincoln.
Thank you, Mr. Speaker. As most of you know, the co-ops were in town today, and one of those people that was here today is Tony Campbell, and we want to honor and congratulate him on his retirement from East Kentucky Power. Tony has led East Kentucky Power in growing more than 20% under his leadership. They now service more than 1.1 million residents across 89 counties, and Tony is very well respected and has been a voice for all of Kentucky at the federal level in order to pass good policy, fight the bad, and keep power costs as low as possible. He's done a great job, and he will surely be missed. And so we wanted to honor him today, and I would ask that you please join me in congratulating Tony Campbell on his retirement. And Mr. Speaker, I move adoption.
Without objection, so ordered. Chair recognizes the gentleman from Christian 9. For what purpose, sir?
excuse me, Mr. Speaker, right there. Communicate with the body.
Yes, sir.
I'd like to announce that House Agriculture Committee will be meeting in the morning, 10:30 in room 154.
Members take note. Chair recognizes the gentleman from Clark. For what purpose, sir?
Call legislative citation, please.
Yes, sir.
I'd like the clerk to report citation 36 by title only.
Clerk, please report.
Citation 36, Representative Dotson. Citation of celebration. The House of Representatives of the Commonwealth of Kentucky hereby recognizes and honors East Kentucky Power Cooperative of Winchester, Kentucky.
Thank you.
Gentleman from Clark.
Thank you, Mr. Speaker. Today we rise to celebrate the 85th anniversary, marking 85 years of exceptional service to Kentucky's rural communities. Prior to 1937, only 3% of rural homes in the Commonwealth had electricity. In response to this dilemma, on July 7th, 1941, 13 owner-member cooperative formed the not-for-profit EKPC to address the need for self-supplying economical generation and transmission of electricity to rural areas across the state. And over the past 85 years, the organization has expanded to 16 owner-member distribution cooperatives that serves more than 1.1 million Kentucky residents, as well as farms, businesses, and industrial opportunities in 89 counties across the state, reliably and affordably generating electricity through 2 coal-fired plants near Maysville and Somerset, and 2 plants powered by natural gas or fuel, all near LaGrange and in Winchester. Over the years, the cooperative has earned a stellar reputation for excellence in environmental stewardship and for its continued pursuit of projects that will ensure long-term, reliable, and competitively priced power for all Kentuckians. Inasmuch as East Kentucky Power Cooperative, with this dedication and hard work of its members, staff, and leadership, has brought new freedom and a better way of life to Kentucky citizens and families. And today we honor East Kentucky Power Cooperative.
Without objection, so ordered. Chair recognizes the lady from Fayette 75. For what purpose, ma'am?
Thank you, Mr. Speaker. I rise to welcome guests.
Yes, ma'am.
The House Minority Caucus wishes to welcome our friends from the Jewish Federation in the Bluegrass, as well as the class members of 2026 for Emerge Kentucky. Thank you.
Chair recognizes the gentleman from Boone 66. For what purpose, sir?
Act on a citation.
Yes, sir.
Mr. Speaker, will the clerk please report House Citation 39?
Clerk, please report.
Citation 39, Representative Roberts, Representative Pfister, and Speaker Osborne. Citation of adjournment. The House of Representatives of the Commonwealth of Kentucky does hereby adjourn this legislative day in loving memory and honor of Logan James Dean Tipton.
Gentleman from Boone.
Thank you, Mr. Speaker. Mr. Speaker, we've heard enough about what happened to Logan Tipton. I want to take a minute to talk about the child that was Logan Tipton. Logan Tipton was an incredible, one-of-a-kind child. He was the treasured son of George Dean Tipton and Heather Pujol Tipton. And by the way, Dean Tipton is with us today in the annex, as we have passed a bill with his son's name. Logan was born in Lexington, Kentucky. He was a loved student at Simmons Elementary. He was taken far too soon at the young age of 6. He was a valued member of the Woodford County U6 Yellow Jackets football team, where he was named the best offensive lineman for Woodford County. His memory was paid tribute once again as this body passed Logan's Law in his honor and joined his devoted family in challenging all of Kentuckians to love like Logan. And that's what Logan did. He loved everyone. He was truly one of a kind, and I think about a story that Dean likes to tell about Logan. Very shortly before his death, he was in a Sunday school program, and Christmas was coming up. The pastor asked the children to write down what they were going to give Jesus for Christmas, for his birthday. Every student wrote something down except for Logan. The pastor asked Logan, why he didn't write anything down. He said that I'd already given Jesus everything that he wanted, which was his heart. He was a one-of-a-kind child, and today we honor him. And for further words on Logan Tipton, who will be forever missed and remembered in this Commonwealth, I yield to the gentleman from Woodford 56 for further remarks.
Chair recognizes the gentleman from Woodford.
Thank you, gentlemen. I don't know what to say about Logan Tipton other than that he was a very special young man that touched a lot of lives. We lost him at a very young age, but I know for a fact that I wouldn't be here today if it was not for him. It was that tragedy that gave me the motivation to run for office in the beginning. I want to thank his father for raising a fine young man. And his father's in my office right now watching this on television. I just don't know what else to say about this young man. I would ask that everybody here, though, join me in a moment of silence for him, please.
Would members please rise for a moment of silence? Gentleman from Boone.
Mr. Speaker, I commend the Tipton family for their fight. This is just the beginning, but we remember Logan Tipton today. I move adoption.
Without objection, so ordered. Chair recognizes the gentleman from Christian 8. For what purpose, sir?
Communicate with the body.
Sir.
Members of BR Sub, Personnel, Public Pensions, and Finance, we will be meeting tomorrow at noon in room 169.
Members take note. Chair recognizes the gentleman from Marshall. For what purpose, sir?
Make an announcement, Mr. Speaker.
Yes, sir.
Our friends with TVA will be hosting a legislative breakfast tomorrow morning in room 125, celebrating 93 years of public power, and it's from 8:30 to 9:30, and everyone is invited.
Members take note. Chair recognizes the gentleman from Jefferson 33. For what purpose, sir?
Make an announcement, Mr. Speaker.
Yes, sir.
I want to announce to the impeachment committee we will be meeting upon adjournment on Thursday, and I recommend you bring your dinner. Thank you, Mr. Speaker.
Any other members seeking recognition of motions, petitions, communications, and announcements? Gentleman from McCracken, you have anything further? Seeing none, the next order of business is introduction of new bills and resolutions. Clerk, please report.
House Bill 705, Representative Tipton, an act relating to post-secondary education. House Bill 706, Representative Tipton, an act relating to post-secondary education. House Bill 707, Representative Doan, an act relating to child support. House Bill 708, Representative Thompson, an act relating to economic development. House Bill 709, Representative Thompson, an act relating to respiratory care. House Bill 710, Representative McCool, an act relating to veterans. House Bill 711, Representative McCool, an act relating to military affairs. House Bill 712, Representative McCool, an act relating to public protection. House Bill 713, Representative Nemus, an act relating to workplace violence against healthcare professionals. House Bill 714, Representative Josh Calloway, an act relating to unborn children. House Bill 715, Representative Wilner, an act relating to the rights of incarcerated minors. House Bill 716, Representative Wilner, an act relating to local school board student representatives. House Bill 717, Representative Wilner, an act relating to health education. House Bill 718, Representative Lawrence, an act relating to expungement. House Bill 719, Representative Scott Lewis, an act relating to education. House Bill 720, Representative Scott Lewis, an act relating to education. House Bill 721, Representative Rudy, an act relating to health services. House Bill 722, Representative Blanton, an act relating to transportation. House Bill 723, Representative Whitaker, an act relating to sales and use tax. House Bill 724, Representative Upchurch, an act relating to transportation. House Bill 725, Representative Kulkarni, an act relating to a deduction for professional membership dues. House Bill 726, Representative Rudy, an act relating to telehealth coverage. And House Bill 727, Representative Riley, an act relating to the Kentucky Educator Placement Service System.
Thank you, Mr. Clerk. Next order of business is a meeting of Committee on Committees and Rules Committee. Gentleman from McCracken.
Let's get ready. Mr. Speaker, I move you, sir, the House would stand in recess for a meeting of the Committee on Committees and the Rules Committee at the clerk's desk.
Without objection, the House stand in recess for a meeting of Committee on Committees and Rules Committee at the clerk's desk. House come to order. The next order of business is a report of Committee on Committees and the Rules Committee. Clerk, please report.
The Committee on Committees has met and referred the following bills and resolution: to Agriculture, House Bill 658; to Appropriations and Revenue, House Bill 652; to the Judiciary, House Bill 653; to Natural Resources and Energy, House Bills 651 and 677; to Primary and Secondary Education, House Bill 649; to State Government, House Bill 650; and to Transportation, House Joint Resolution 71. The Rules Committee has met and posted the following bills and resolutions to the regular orders for Wednesday, February 25th, 2026. House Bills 190, 486, 516, 518, 521, and 534.
Thank you, Mr. Clerk. The next order of business is introduction of floor amendments. Please report.
House Floor Amendment 3 to House Bill 1, Representative Bojanowski. House Floor Amendment 4 to House Bill 1, Representative Bojanowski. House Floor Amendment 5 to House Bill 1, Representative Lehman. House Floor Amendment 6 to House Bill 1, Representative Rourke. House Floor Amendment 1 to House Bill 2, Representative Moore. House Floor Amendment 2 to House Bill 2, Representative Moore. House Floor Amendment 3 to House Bill 2, Representative Burke. House Floor Amendment 4 to House Bill 2, Representative Burke. House Floor Amendment 5 to House Bill 2, Representative Burke. House Floor Amendment 6 to House Bill 2, Representative Burke. House Floor Amendment 7 to House Bill 2, Representative Rourke. House Floor Amendment 8 to House Bill 2, Representative Rourke. House Floor Amendment 9 to House Bill 2, Representative Stevenson. House Floor Amendment 10 to House Bill 2, Representative Stevenson. House Floor Amendment 11 to House Bill 2, Representative Smith. House Floor Amendment 12 to House Bill 2, Representative Bojanowski. House Floor Amendment 13 to House Bill 2, Representative Bojanowski. House Floor Amendment 14 to House Bill 2, Representative Burke. House Floor Amendment 15 to House Bill 2, Representative Burke. House Floor Amendment 16 to House Bill 2, Representative Burke. House Floor Amendment 17 to House Bill 2, Representative Burke. House Floor Amendment 1 to House Bill 227, Representative Lockett. House Floor Amendment 1, the title amendment to House Bill 519, Representative Kleins. And House Floor Amendment 1 to House Bill 621, Representative Bojanowski.
Thank you, Mr. Clerk. The next order of business is adjournment. Gentleman from McCracken.
Mr. Speaker, I move you, sir, the House shall stand adjourned until the hour of 2 p.m. Wednesday, February 25, the year of our Lord 2026.
Without objection, the House will stand adjourned until 2 p.m. Wednesday, February 25th, the year of our Lord 2026.